Welcome, friends, to this part 10 of AEFS. Argue in English fluently and confidently. So, with each and every session, your arguing skill is enriching. Using proper vocabulary in apex court, high court is very essential. It will get impact on the judges, on the colleagues, on the juniors also. So using proper word many times, like manifestation, I want to manifest following significant points. So like that, there are so many words. Now we'll start the words meaning, but before that, as usual, we have to take the practice of tense. So take any verb. For example, I am giving you verb today, search. Search, search, search. Past participle is search. So use search word and complete 4 type of present tense. Simple, continuous, perfect, and perfect continuous. So, Advocate Nidin, will you start?
Yes, sir. Yes.
Yes.
Good evening, sir. Good evening.
Good evening.
Which word you have given?
Search.
Search. Okay. May I start, sir?
Yes, yes.
I search judgment from the book.
Yes.
I am searching judgment from the book.
Hmm.
I have searched judgment from the book.
Hmm.
I have been searching judgment from the book.
Correct.
Next.
Yes. You said
tense,
I. Now I said we.
Okay.
I, we, you, he, she, it, they. You have to complete all 4. All.
We search judgment from the book.
Hmm.
We are searching judgments from the book.
Hmm.
We have been searching.
We have searched.
We have searched judgment from the books.
Hmm.
We have been searching judgment from books.
Correct.
You search judgment from book. You have searched. Sorry, you are searching judgment
Correct.
from book.
Hmm.
You have searched judgment from book. You have been searching judgment from book.
Correct.
They
Next.
search. They search judgment from book. They are searching judgment from book. They have searched judgments from book. They have been searching judgment from book.
Correct. He, see it.
Yes. He searched judgment from book. He is searching judgment from book. He has searched judgment from book.
Correct.
He has been searching judgment from book.
Correct. C.
She searched judgment from book. She is searching judgment from book. She has searched judgment from book. She has been searching judgment from book.
Correct. Now, Manoj, same word, same verb, search. You have to use past tense.
Okay. I searched, you searched, he searched, she searched, it searched, they searched.
Little, a little bit, little mistake is there, but no issue. On in continuous, you can correct it.
I was searching,
Hmm.
you was searching,
We.
he was.
I was searching. We were searching.
We were searching.
Yes.
You were searching. He was searching. She was searching. It was searching. They were searching.
Correct. You also two times you. You were two times. Next.
One singular, one plural. I had searched. We had searched. He had searched.
You.
Sorry. You had searched. You had searched. He had searched. She had searched. It had searched. They had searched.
Correct.
Past perfect continuous.
Correct.
I had been searching. We had been searching. You had been searching. You had been searching. He had been searching. She had been searching. It had been searching. They had been searching.
Correct. Now future tense. All four. Nitin.
Future.
Ha.
Yeah. Future indefinite. I will search. We will search. You will search. You will search. He will search. She will search. It will search. They will search.
Correct.
Future continuous.
I
will be searching. We will be searching. You will be searching. You will be searching. He will be searching. She will be searching. It will be searching. They will be searching.
Correct.
I will have been searching.
I will have searched.
Okay, so that's perfect. Future perfect. I will have search. We will have search. You will have search. You will have search. He will have search. She will have search. It will have search. They will have search.
In he, she, it. Instead of have, has should be there.
Yeah, I told has only.
Okay. Oh, then it is correct. Okay. Yes, and perfect continuous future tense.
Yeah, future perfect continuous. I will have been searching. We will have been searching. You will have been searching. You will have been searching. He will has been searching. She will have has been searching. It will has been searching. They will have been searching.
Correct. Correct. Good revision. Now we are sharing. I'm sharing you now the vocabulary which Santosh had sent on this our group. Now you have to read word, its meaning, and use in your own sentence. Okay.
Yeah.
I will start from myself. Intent. Intent means resolve or determination of anything. So intention or purpose, you can say. So I intend to argue very confidently and clearly to get justice for my client. Now second word, Manoj.
Inception. The establishment or a starting point of an institute and activity.
Beginning, start, onset, initiative, inception.
Inception, beginning and starting.
Use in your own sentence. Inception. You can use incept also. Incepting, incept, incepted, inception. It means beginning, start.
Inception is basically noun.
Yes.
Yeah. Inception of any case should be focused on facts of the case.
Not perfect use in sentence. I want to incept one para before arguing in front of the court. Incept. Incept means to begin, start, onset, initiative, like that. Nitin?
Even in this case, since inception of the argument.
Yes. Nitin, third word.
Yes, sir. Undergone.
Yes.
Experience or be subjected to something, typically something unpleasant, painful, or arduous. I have undergone my case to explain before the court.
Good, but not a perfect. Undergone.
Sorry, it's typically something unpleasant.
Yes.
That's why the sentence is not correct.
Unpleasant means your client.
Yes. My client undergone.
Correct.
Undergone.
For last 6 months.
For last 6 months. So next, how to use?
Yes. Next word, hesitate.
Hesitate.
Use. दो लेने का यार. Two words at a time ले लो.
Before saying or doing something. When I argued before the High Court, then I hesitated before the judges.
Correct.
Integrity.
Yes. Integrity.
The quality of being honest or having a strong moral and principle.
Read all meaning, all alternative word also read the meaning.
Righteous, sincerity, faith, fairness.
Correct.
During the electronic evidence, integrity should be checked of the data.
Correct. Good. Another word?
Authenticity. The quality of being the authentic. The authenticity of the evidence, secondary evidence, should be checked by the court.
Okay. 7 and 8, Nitin.
Formulate, create or devise methodically, strategy or a proposal.
I formulate some sentences
The
or
court,
some maxims.
The court formulated the case. The court formulated the case.
Daily, whatever word we are learning in this session or during our course, and if you regularly using these sentences early in the morning, this word into your own sentences, that time you can easily add on this vocabulary in your talkative English. And that will be impactful. So this practice is there.
Yes.
Next.
Encryption. The process of converting information or data into a code, especially to prevent unauthorized access.
Encryption, process of converting information or data into a code.
Especially
encryption.
To prevent unauthorized access.
That video is very nice, very informative information is given, and which video I have given you yesterday, that also a great video, very good words, and Manoj Chaudhary have already found difficult word that we are there. Only use these words again and again to get the mastery on legal English. Now, envisage.
Contemplate or conceive of as a possibility or a desirable future event. Envisage.
Yes. Think, pursue, deliberate, and envisage.
Think,
contemplate, or
envisage.
conceive. Think, pursue, deliberate, envisage.
Envisage.
Contemplate.
Is it my turn?
No, that contemplate means pursue of an possibility or desirable future event. When something it definitely happen in future, or something it definitely happen in near future, that time we can use I contemplate that it will happen, and I was contemplated that time, like that. So contemplated and envisage are similar words. Okay, these are the synopsis. Synonym. So envisage is also like, you can use like contemplate. So I envisage is certain thoughts in mind which may be contemplate in future. So we can use envisage and contemplate also in one sentence also, but at different places. Okay. Last, now 10.
Cryptography. The art of writing or solving codes.
Correct. Forensic person or forensic personnel should have an art of cryptography. Because without a cryptography art, they cannot decode any secret messages.
Secret.
So forensic experts should have that. So this can be a use of in sentence.
Digital
Regularly.
signature in cryptography in its process.
Yes. Regularly take only 3 words every day in the morning. Give only 15 minutes.
Yes.
15 minutes is also much more. If you give only 5 minutes and take 3 words and use each word in 5 different sentences, use that. So that will be a great thing. That practice should be there. Now,
Yes, sir.
we have to cover our syllabus. Now, can you elaborate what was in that video exactly? Electronic evidence. In short, Manoj, have you seen that video?
No, I couldn't able to go through that video.
Okay, okay.
But I can, that the second one I can explain. Success of.
Yes, yes. You take the case. Siddharth Singh Rawal. You argue on behalf of petitioner.
No, you're talking about the video, the second video you sent.
Okay, okay. But that is not our today's part. That will be our next
Okay.
Next Friday's part. So Siddharth Singh Rawal, I have given you full bunch of Siddharth Singh Rawal, which is on the CPC Order 9, Rule, I think 9 or something on that. And already I have admitted this SLP in Supreme Court. Now it is under process. So argue from the perspective of petitioner.
So actually, I missed that case. I worked on that you call Supreme Court procedure and Supreme Court rules.
Okay, 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 okay. So then elaborate Supreme Court jurisdictions. Tell me Supreme Court's 5 jurisdictions, any 5 jurisdictions.
Yeah, according to the Supreme Court procedure 2017, the Supreme Court has a jurisdiction of appellate jurisdiction. Then it has a extraordinary appellate jurisdictions under section under Article 136, in which we submit the SLP. We have a original jurisdictions for Article 32 and 131, 139A. Then we have a original extraordinary jurisdiction for Article 32. Then we have a advisory jurisdiction where we can get a referral from the president or refer from the any particular high court cases, reference cases.
Okay.
Article 143. Then we have one more jurisdiction that we call our inherent and what is used as a plenary jurisdiction.
Plenary,
Inherent and plenary jurisdiction, that is basically absolute jurisdiction in case of Article 129, Article 142.
Okay.
And for the curative petition also for Article 137.
Good. You have already mentioned 5. Transfer jurisdiction is there, original jurisdiction is there, writ jurisdiction is there. Okay. So you can elaborate all these 5 to 7 jurisdiction into 8, 9, 10 jurisdiction also. Statutory appeal jurisdictions like that. So there are so many jurisdictions, suo motu jurisdiction, suo motu writ petition they are taking, suo motu action they can take, suo motu jurisdiction is also there. So Supreme Court jurisdictions are there. Good reading. Now, Nitin, tell what are the Supreme Court jurisdictions?
Sir, there is the original jurisdiction.
Yes.
First of all.
Can you give example of any original jurisdiction?
Original jurisdictions means any writ petition filed under Article 32.
Correct.
Is the original jurisdiction. And then appellate jurisdiction.
No, original jurisdiction, one more example, 1, 2, 3 example you can give. The dispute between two states. Yes, dispute between two states will be Supreme Court have to invoke the original jurisdiction. Difference dispute between central government and any state government is also come under original jurisdiction. So these are the example of original jurisdiction. Then tell next jurisdiction.
Appellate jurisdiction.
Appellate jurisdiction. Give some example.
Any decision or any order passed by High Court, then the impute judgment has been challenged in the Supreme Court. It's called appellate jurisdiction.
Correct. One more example of appellate jurisdiction. High Court order we can challenge. Okay, yes. With the certificate of appeal or under Article 136 in the form of SLP. High Court order can challenge. But in appellate jurisdiction, we can challenge any other order also. That is called statutory appeal. So can you give me some examples of statutory appeals?
Statutory appeals, no sir, I don't have any idea about that.
Armed Forces Tribunal. Armed Forces Tribunal appeal will directly come to the Supreme Court. High Court don't have the jurisdiction for Armed Forces Tribunal. Armed Forces matter also not come under Article 136 because Article 136 is related to SLP and the wording of Article 136 is any judicial order can be challenged directly into the Supreme Court except Armed Forces Tribunal matters, Army matters. So under Armed Forces Tribunal, there is section 30 and 31 under which direct appeal come to the Supreme Court. So section 30, if AFT is giving permission for appeal, so party have to file one application to take the permission to the appeal in Supreme Court from the AFT. AFT means Armed Forces Tribunal. And if Armed Forces Tribunal giving the order, positive order to file appeal in Supreme Court, so that appeal come under section 30 of the AFT Act. But if AFT denies to file the appeal in Supreme Court, that time section 31 is applicable of AFT. So under section 31, when we put that appeal, when Armed Forces deny that. So Armed Forces consent for appeal or denial of appeal. That order should be there. And according to that order, we can invoke section 30 or 31. If AFT is giving permission to file the appeal, that time we invoke section 30. And if AFT denies to file the appeal in Supreme Court, that time we can invoke the section 31 jurisdiction. appeal. Same type of armed forces tribunal matter are also come to Supreme Court. National consumer matter also come to Supreme Court under statutory appeals. NCALT, NCLAT, Competition Commissioner or NCLT, both appeal are handled by NCLAT, National Company Law Appellate Tribunal. So, NCLAT appeals are also coming to the Supreme Court. These are the statutory appeals. Then water dispute tribunals. Water dispute tribunals appeal are also coming to Supreme Court. Then National Green Tribunals also appeal comes to the Supreme Court. So there are so many statutory appeals other than High Court also in the Supreme Court. So always remember, Supreme Court is the OSIN of the matters. So all rivers, all streams comes to the Supreme Court. Okay, and they are getting properly involved in the process of giving proper justice to the people of the India. So these are the jurisdiction. Nicely prepared. You all prepare very well jurisdiction of Supreme Court.
Yes.
Now, tell me, Santosh, what is the difference between Supreme Court Rule 2013 and Supreme Court Procedure and Practice 2017? What is the difference between these two books?
Actually, sir, my two matters has been listed before the High Court yesterday and today, so I did not prepare. And I did not read, so I'm very sorry for that.
If you use common sense without reading, also you can give the answer. If you use common sense, just use common sense. What will be the difference between Supreme Court Rules 2013 and Supreme Court Practice Procedure 2017? This is my question.
Okay.
I congratulate for your today's matter. You got two matter listed, and in future somebody contact me for High Court references, or maybe that matter comes to me, then I will hand over that matter to you, or special court matter, that is a CBI matter. So in CBI court, you have to file that matter, you have to argue that matter, and if it is online available argument, then I will also join for argument. No issue for that. So we'll discuss that thing when matter comes to me. So this is good thing. But if you use just a common sense, you can give the answer. What will be the difference between these two books?
Yes, sir. Actually, I didn't read, and I don't know about the Supreme Court.
Tell me what is the difference between IPC and CRPC?
CRPC is a procedural law. Hello?
Correct. And IPC is?
IPC is a penal law.
IPC is a regular law, okay? And CRPC is the procedure of this regular.
IPC basically sets the rights and obligations to the person.
Correct. And now similar difference is there between. Similar difference is there between Supreme Court rule. Supreme Court rule is the law of Supreme Court procedure, and practice and procedure is the detailed procedure of that law. So similar, like a custom law, custom procedure. In our country, law are different and procedure are different.
Basically, we can say that the Supreme Court derives the power from the Supreme Court rule, and from the procedure, how it will work, that is given in the procedure.
Correct. To make rules is the power given to Supreme Court by the Constitution.
Okay.
And to make the practice and procedure of that rules is the inherent power of the Supreme Court. So this also you can tell this difference. Santosh, have you prepared the argument of Siddharth Singh case? Siddharth Singh Rawal case?
Hello?
Have you prepared that argument?
No, sir, no, I have not prepared.
Okay.
Literally,
Then
I
am
didn't get time.
shifting. I am shifting this argument, same argument for our next batch. So I am not giving you new argument. Okay. Same Siddharth Singh Rawal argument you prepared, and on Friday we will take that. Okay. On
Sir,
Friday.
I had one question.
Huh?
I had one question.
Let me finish. On Friday, Santosh, you argue from the perspective of the petitioner, and Manoj, you argue from the perspective of the respondent.
Okay.
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 And while arguing, you try to disturb to each other, like a courtroom. Okay. Then I will stop somebody and then allow to speak somebody. Okay. Nitin, you prepare both sides. You prepare from the perspective of petitioner also and from the perspective of respondent also.
Yes, sir. Yes. Sir.
Okay. So similar argument we will take on Friday. And Friday we will take some vocabulary also, good vocabulary. And Friday we will give you some input of statutory appeals, under which sections statutory appeal are coming to the Supreme Court, like that. Suppose, for example, arbitration matter. Which arbitration matter are coming to High Court and Supreme Court? So such type of good things, good input, I will give you in Friday batch. So what is our next? Practice procedure we completed. Argument, Manish case for advice. Manish Kumar case for advice. That is a High Court order, and that High Court order comes to you. For giving guidance. Just open it. Okay, I'm pausing. I'm pausing recording. I'm giving you 10 minutes to read that. Okay. And after 10 minutes, I will come again and you have to give advice. So you have in WhatsApp, you open it, read it. 10 minutes is more than, but six pages order is there. So you have only 10 minutes. Always remember that. Read facts, starting facts, and read the ending judgment. Judgment, why High Court has not given the relief. See that. And accordingly, you can guide client how that client will get the relief from the apex court. And insist that client, show that client some positive points which are in your mind, like that. So I am giving you 10 minutes. So this is gap for me. This is not a gap for you. But you can leave this place. You can go anywhere. You can read it, but don't leave meeting room. Meeting room will be as it is. Just I am pausing that. Welcome back after break. I have given you 10 minutes to prepare your advice for the order which you received from Manish Kumar. Manoj. Unmute yourself, Manoj.
Yeah.
And give your advice.
Actually, the job was on a contract and it has been renewed. And now they are not renewing because they have approached to the SSC for the...
No, your voice is not audible.
Hello?
Yes.
Am I now audible?
Yes. Now it is audible.
I am also finding some delay today. Some network issue. So actually, you have lost your job and you are working on a contract for this corporation, but now they are not renewing. And so you approached via the writ to the High Court. And you feel now you want again to the Supreme Court. In fact, we might have gone in this case to the labor court. That might be the better option, but now we cannot reverse back, you tell. But we have an option to go to the Supreme Court and taking the constitutional right that everybody should have work in their hand for the livelihood. So we can take that stand. On this stand, we can approach to the Supreme Court to get your work back.
Santosh?
This is all my submission. Will it work for you?
Anyone point? Any other point you want to mention? One important point is there.
Yes, sir. Sir, first of all, the order has been passed by the High Court is against the natural justice, and the respondent writ petition was for quashing of action of respondent under despite the letter of extension. The letter of extension dated 6/3/2019 has been given by the corporation. And as per that letter, they have to extend, but they have not extended and not allowed the petitioner to join for the job as a junior engineer, civil and electrical. And even there is availability of post. And communication letter dated 4/6/2021 is also there, which shows there is a power. There is a power of outsources, but they have not done the requirement, or they have not taken the persons or hire that post, junior engineer, from the corporation. So in that case, we also filed the appeal in Supreme Court against that impugned order. Correct. And even after reading that judgment, you can also file the civil suit for damages. For the damages, this is the second option is available for you. You can file a damages suit for the compensation.
Yes.
Why? Because there is a 1 year and 1 year and a half, 1 and a half years service has been break by the corporation. So you can claim for the damages for that. So this is my advice for you.
Okay. Nitin?
Yes, sir.
Yes.
So actually, the respondent, the corporation, despite the issuance of letter of extension dated 6/3/2019, 6 March 2019, they have issued the extension letter, but after that they had not been allowed to join the job. It means that it is against the natural justice, and when the extension letter was issued by the corporation and after that they have not joined, it is the legality of the corporation, sir. We should go to the Supreme Court on that point. Sir.
Correct.
Because we have not illegality. Legally, we have not done anything. We are doing our job. But illegally, as per the extension letter, they have not joined us. Therefore, we should go to the Supreme Court, sir, on that point.
Yes, good try. One more point I want to add. Respondent has not followed the process of termination. So always remember to raise these questions. Whether they followed process or not, judiciary will decide you. But we should allege the respondent has not followed the process of termination. They should give the advance notice at least 1 month, but they have not given notice. They have suddenly terminated like that. So such type of question we should raise for admission hearing. So when there is a vacancy available and even they are not giving chance to regular their contract employees to continue as a continuous employee who are engineers, and 1 year, 2 year, 3 year they have renewed. And one more argument is that slavery is abolished from India is given in the constitution, but slavery is still into existence in the form of contract labor. So contractual labor is the injustice with the labor. When you have the capacity to pay, when you have the vacancies to the fulfill, even though you are using contract labors, so using contract labor is like a slavery. So slavery is abolished from India, but it is still into existence in the form of contract labor. I have argued in such a way in this particular case, and a very fine argument was on that time. Both judges agree. Yes, Mr. Somani, we agree. Slavery is into existence in the form of contract labor, but that care should be taken by the parliament. Parliament should pass proper law, but no government can compel. No government can compel to any employer to give the full-time job, to permanent job. So that is the hands of employer also, employee also. So this thing will happen, and so service matter will regularly comes into here. I like one advice of Manoj Chaudhary is very well. Instead of going to High Court, if that fellow is approached to Labor Court, that will be a better. Because Labor Court have the full power to take the evidence, to take the trials, and they can adjudicate matter in very well. High Court is the appellate court. So High Court cannot take the trial. High Court can give the judgment on the basis of only documents. There should not be a cheap examination, cross-examination, examination of witnesses, examination of documents. So whenever there is a chance to go in trial court, party should always go to trial. And when there is a great injustice in the form of fundamental rights, legal right infringement, So legal right infringement is come under the 227, Article 227 in High Court. And fundamental rights are coming into 226, Article 226. These are the special power given by Constitution of India to our High Courts. Supreme Court have a very less power in writ petition. Supreme Court have only Article 32 power. So Supreme Court can entertain only fundamental right infringements. Supreme Court cannot take the legal right infringement. Legal right infringement always be seen by the High Court, and when High Court is not giving proper justice, that time against that order, against the High Court order, regular SLP can be filed in the Supreme Court. This is the hierarchy of our judicial systems. So friends, good try. You already, if you give only 10 minutes, you can give a very good input. Okay. And when I am giving you 2 days, 3 days to do the practice of argument, and you are telling, I am not prepared, I have not seen that. So Siddharth, Raval case prepared, that is very fine case. That is very good case. So read it properly, read the impugn order, read the synopsis, read its question of laws. So first read the order of the High Court in that order of the High Court. You will always find on page number 1 some A2, such that A, B, C, D, such pages. That is a synopsis. Impugn order is always number 1. And after High Court order, then regular SLP will start. Then question of laws, grounds, then interim relief, prayer, interim prayer, like that. Then certificate of AOR, you can watch. Now, I want to add one very good input. This is a new input on behalf of me on today's occasion. So let me show you that. I will give one book. Five types of legal arguments. This is foreign book. The 5 types of legal arguments. Introduction to the 5 types of legal arguments. Textual arguments. Plain meaning. Canon of construction. And intellectual arguments. Why are there hard cases Why do informed and reasonable people differ as to what the law is? Intent, text, intent, precedent. Precedent means case laws, tradition, policy. Not all arguments are legitimate. Each type of argument is a proof of what the law is. To prove the question of fact, lawyer call witness and introduce exhibits. To prove a question of law, lawyers create a valid legal argument, drawing on legal text, intent, precedent, tradition, and policy. The different legitimate types of legal argument are the data that lawyers use to prove what is the law. The different types of argument operate as a rule of recognition. The legal philosopher H.L.A. Hart said that the underlying the law are rules of recognition, rules that govern what counts as a law. The 5 types of legal argument operate as a rule of recognition. Judges and lawyers recognize argument based upon the text. Argument is always based upon the text, then intent, then precedent. Precedent is a different. Precedent means if any things superior court has explained in any judgment, so that judgment is a precedent to explain that particular law. So precedent you can call that case law. Tradition. If some tradition is there, in one tobacco matter, I argued in Karnataka, a Andhra tobacco matter was with me. Senior lawyer Abhishek Manu Sanghvi, Dr. Abhishek Manu Sanghvi is also from our side. We both argued that case. But I argued in different way. I argued High Court has given the order tobacco should be banned because it is very dangerous for health, like that. But tobacco product law is there. Government have passed that law. GST committee has classified that product. We are paying GST to the government. So it is our legal right to sell that product in the state. How High Court can stop that? On the basis of emotions. Cigarette smoking is injurious to health is written on the package of the cigarette. We are following the law properly. But even though High Court has not considered our, and from the era of Acharya Chanakya, I want to explain you the tradition. From the era of Acharya Chanakya, from 2500 years back, tobacco is the trading in our country. In Kautilya Artha Shastra, there is the classification and there is a chapter to charge the tax on tobacco. And similar chart is in GST system now. So when government is passing one law, government is giving the guidelines, and after that, all of a sudden, any court is passing the decision, this product is not good for sale. How it is possible? So this is the part of the parliament. Parliament should pass the law. This is not the part of the High Court or Supreme Court. So such type of argument we have argued. So this is called tradition. If tradition is there and policy. So policy, government policy, yeah, state government policy or employer policy is legitimate. That form the legal arguments. Text, intent, precedent, tradition, and policy as being legitimate form of the legal arguments. So I will share this with you. One more book I want to show you. In each and every now part, I will give you some books. In today's part, I will share you two books. This one and this one I think already given. Law of Argument and Theory. So this is very short. Introduction, argumentation, and legal justification. In the past 30 years, study of law and argumentation has become an important interdisciplinary discipline. It draws its data. Assumption. You read it at home. Then we will discuss in next to next. The logic approach. Your approach should be a logic. Everyone who summoned to the court as a witness is obliged to appear in court. Mr. A is summoned to the court as a witness. Mr. A is obliged to appear in the court. So this is for your Friday's homework. Friday, Siddharth Rawal case is there, argument. Okay. I have already classified that. Who will argue on behalf of petitioner, who will argue on behalf of respondent, and who will argue on behalf of both. And this book and that book, which I have shown you earlier, that is short, but this is little bit big. You read it properly. And you give me the information, some tip regarding the approach of this book for our argument skills. How many pages? This. 17 pages. These are the references. Total 20 pages are there. I will share those two books. To argument skills. Go through it sincerely. Every day in the morning, take 3 words. You have already vocabulary. You take 3 words and use each word in 5 different legal sentences. 5 different legal sentences. That time that vocabulary can be added into your vocabulary. Without using that language, you cannot get the mastery. Memorizing word is not sufficient. using that word into our language is more important. So you do that. And one more video I will share with you for finding the vocabulary. And you will get good knowledge from that. That is cybercrime. One my friend is a master in cybercrime. He has written more than 121 books on cybercrime. So I will share his video tomorrow morning or today evening. I will share you that video. Mostly maybe tomorrow morning I will share you that video. You watch it. Difficult word are not more, but that is a very knowledgeable video. And same person's video I will show you in part 13 or part 14 for understanding and for a current scenario of legal practice to use artificial intelligence, AI. Artificial intelligence in current scenario, how lawyer can use. He has given in one lecture. So I will share my friends. He's our Rotary Club New Delhi member also. He is our Supreme Court lawyer. So Pawan Duggal, his name is Pawan Duggal. So Pawan Duggal's one video I will share you tomorrow, and one video of artificial intelligence video I will show you, share you in part 13, 14. So hence this is a part 10 now. We balance part is 6 parts. In 6 parts, I will give you more inputs. So practice it very well. After completion of course, you again take your course as per your, you have the videos, then take these videos, take the practice, you have the folders, you have the case laws, you have the everything. You do that. Okay. And I want to give one more homework to you for research. Find out 2 case laws. 2 case laws on FEMA, Foreign Exchange Management Act. FERA. In older days, it was called FERA. This foreign currency is coming to our country. Foreign currency is going from the country. But certain limit is no restriction. Up to $1 lakh, sometime up to $25,000. No restriction in that. You can do it. But when any businessman, without any business or without any proper invoices, proper scenario, when they are bringing foreign currency into their account, or when they are remitting foreign currencies from their account to abroad, and when that infringe law. So this is very serious matter. And PMLA Act, Prevention of Money Laundering Act, and FERA, these 2 laws are being controlled. These 2 laws are controlled by ED, Enforcement Directorate. Other laws are controlled by police, CBI. But PMLA Act and FERA, 2 acts are controlled by ED, Enforcement Directorate. So on FEMA, find out 2 case laws. Okay. and you have to give some information of any one case laws which you find. Because we have the less time here. So we will take any case, one case laws. So FEMA, I have given you different subject because ED enforcement director, when big leaders, big businessman traps into the tricks of the PMLA Act, HERA. I have my book on FEMA laws, FEMA case laws, HERA case laws. I have one book of PMLA case laws on Amazon, Flipkart. You will find the books. So it is very easy for High Court practitioner, for PMLA, and these cases are conducted under special court. Special court act is there. So in regular session court, they are not conducting the case. Special courts are there. Procedure is same. Procedure is CRPC procedure. Like NDPS Act also conducted, NDPS matter also conducted by a special court. But what is the little bit difference is that, like our ordinary criminal cases, investigation, police should complete investigation and file charge sheet within 90 days. But in PMLA Act, HERA, NDPS, in such act, the limit of this research, search, investigation, and filing charge sheet into their court is 180 days. So 90 plus 90, 180 days. Such type of difference is there. But practical approach you will get by searching. So our next session is on Friday, coming Friday, from 7 p.m. to 9 p.m. I will not postpone that session. मैं पोस्टपोन नहीं करूंगा फ्राइडे का सेशन. आप भी कंप्लीट अटेंड कीजिए. यहां से आगे का कोई सेशन मोस्टली पोस्टपोन नहीं होगा. एक भी है तो मैं लूंगा क्योंकि मुझे जून एंड तक एक पूरा खत्म करना है. फ्रॉम 22 जुलाई वी आर स्टार्टिंग न्यू बैच. और न्यू बैच हम थोड़ा सा अलग ढंग से स्टार्ट करेंगे. तो वो हिसाब से थोड़ा सा जस्ट प्रिपेयर योरसेल्फ. I have given a very little homework. ये 2 बुक हैं, ये 2 बुक पढ़ के आओ. वो सिद्धार्थ रावल का केस आर्गुमेंट के लिए तैयार करके आओ. मैं आपको एक वीडियो दूंगा दुग्गल का. वो दुग्गल का वीडियो देखो, पवन दुग्गल का. उसमें डिफिकल्ट वर्ड ज्यादा नहीं है, लेकिन जो भी डिफिकल्ट वर्ड है वो डिफिकल्ट वर्ड नितिन आप ढूंढेंगे. पवन दुग्गल्स डिफिकल्ट वर्ड, पवन दुग्गल्स वीडियो डिफिकल्ट वर्ड आप ढूंढेंगे और वो वर्ड मीनिंग के साथ अपने ग्रुप में डाल देंगे. तो फिर वो एक हमारे पास वोकैबुलरी और ऐड हो जाएगा. कितना सिंपल वे से वो बात करता है. कैसा बात है, जैसा कि लगता है कि वो मदर टंग ही उसकी इंग्लिश है. ऐसा पवन दुग्गल बात. बट हिज हिंदी इज ऑल्सो बेटर. व्हेन ही इज स्पीकिंग इन हिंदी, हिंदी इज ऑल्सो बेटर. So this is the practice. When we do the practice and when we continually start the communication, automatically we get the mastery on our languages. But communication is important. If grammatically we are little bit doing mistake, no. Court will excuse you definitely. But that should be a material in your speech. There should be an emotion, there should be a case law, there should be a fact, there should be a law properly, there should be a link. In argument, sequence of your thoughts should be in a such a way that should be appeal to the judges. Yes, ये बोल रहा है, सही है, ऐसा ही होना चाहिए. This is the right thing to do. Like that. So, this is for today. I think some network issue is there from the side of Santosh, Advocate Santosh. He is leaving, he is again catching our conference room. So next Friday we will meet. Till then, goodbye. Have a good days, your working days. And you shared me your feedback about this program. In 4 to 5 lines, write your good feedback and share in our group. So we want to put that feedback in social media. We want to put feedback in our next circular. Next circular, we will add the feedback. So more people will get the benefit of this batch. Only 2 to 3 batches I will take. Then I will stop this arguing this because I have to focus on my Supreme Court practice. This is very lengthy. You already see 2 hours we have to take. Like